Hello, Roger Royce with the 10,000 Startups podcast. Today I'm talking about the California Fair Investment Practices by Venture Capital Companies Law. That's a mouthful. But you may recall from previous podcasts that California created a reporting regime to increase transparency regarding the diversity of its portfolio companies receiving venture capital funding. And it used to be, or the law was, that covered entities, meaning venture capital firms doing business in the state, broadly defined, were required to register with the California Department of Financial Protection and Innovation by March 1. Well, it's April 1 as I record this. And of course, March 1 is coming past, and today was to be the deadline that VCs had to submit aggregated demographic data reports. You'll be happy to know that those deadlines have been suspended. And as of this date, that reporting is no longer recovered, but you might want to keep an eye on this because this may be back. In fact, it probably certainly will be. Now, recall that this law was intended to cover venture capital companies that primarily engage in investing in startup, early stage, or emerging growth companies, and that have a California nexus. Now, California nexus doesn't take very much. An entity has a California nexus if it's headquartered in California, if it has a significant presence or an operational office in California. It makes a venture capital investment in a business located in or with significant operations in California, or even if it receives or even solicits investments from a person who's a resident of California. It is pretty hard not to have nexus under that broad a standard. If you are a covered entity and if this law becomes unsuspended at some point, then the VC is going to have to provide standardized demographic data or survey data, a survey to the founding team members of the businesses that they invest in, aggregate those responses, and then provide that data back to the DFPI, the state of California. Now, the portfolio company participation is voluntary. They could say no. The VC can't say no. They're going to have to go through the steps. Big penalties, up to $5,000 a day for noncompliance. And there's a web page that helps companies comply and will give you guidance on whether you're subject to these rules or not. It is, as a lot of California legislation, it's broadly drafted, poorly defined. It's probably why it's been suspended. It kind of took a lot of people by surprise. But keep an eye on this because this may come back and this may apply to you. Roger Royce, 10,000 Startups.